Good morning and welcome to Get Real with Attorney Martinez. Today's topic is escrow disputes. This is an informal roundtable. After the topic presentation, we'll open up for question and answers on this or any real estate topic. For those of you on Zoom, if you experience freezing, disable your video. I am Jennifer Canizzo, paralegal with Martinez Law, and I'd like to introduce Attorney McElherron and our legal assistant, Javier McCool.
All right.
Now, Attorney Martinez.
All right. Thank you all for coming. If you are here on Zoom, if you could go ahead and mute yourselves just so that there's not any background noise. And then when we do open it up for question and answers, you can, of course, unmute yourself to ask your questions, or you can always throw your questions into the chat as well. There are several new names and faces attending today, which is wonderful. So I'm going to take a couple of minutes just to introduce myself and the firm. My name is Cristen Martinez. I started Martinez Law back in 2015. Since day one, we've been a full service real estate law firm. We haven't practiced anything else. We don't practice anything else. This is our specialty. This is what we do. We've recently grown and added attorney Tiffany McElherron. She is a partner with our firm. She joined us last December. So we are super excited to have her. And while she practices all real estate law, she really focuses and specializes in condo association and homeowners association law. So that is something that we're really focusing on this year. And so if you have any questions in that regard, or you have you're part of an association or know of an association that is in need of assistance, if you could reach out to Tiffany, that would be wonderful. I also want to give a couple of firm announcements. If you've attended my events in the past, you're probably sick of hearing this, but all real estate agents, real estate professionals, title agents, investors, you all get a free 15-minute consultation with me. So as you are out there in the field working with clients, working on transactions, and something comes up, you have a question, you're not sure how to handle it, please reach out to me. That's what we're here for. I'd much rather you reach out on the front end and do things properly than maybe guess or do something that you're not 100% confident on, and your clients are calling me down the road to clean up a mess. That's not what I enjoy doing. Although we can definitely help in those situations, I would like to keep you and your clients out of them. So please utilize that. Shoot me an email, give our office a call if you have questions on anything. Also, I mentioned this at our last month's Get Real with Attorney Martinez, but we just recently launched flat fees for all of our litigation matters. So we've always done flat fees for document preparation. We are now offering flat fees for litigation matters as well. So what that means is when you come to our office with a case or a potential dispute, I can quote you a flat fee up front so that you or your client more than likely will know exactly what the case is going to cost from start to finish. And that enables you and the client to make an informed decision on whether you want to even pursue this, whether it's going to be worth it, whether this is an investment that you want to make into this type of case. So it's been working out great. Clients have been loving it so far, and we've worked really hard on it, and we're really excited to be able to offer that to our clients. So I'm going to go ahead and get into the presentation. I do have a PowerPoint, so if I can figure out how to share my screen. Oops, let me admit Veronica. All right. I'm going to do that, and then I'm going to do this and this. Did it work? Yeah, but can everyone see?
Can someone unmute themselves and let us know that you see the PowerPoint presentation?
Are you all able to see my screen? And I don't know where the I don't know where like the chat and the participant are. I want to be able to monitor that. It doesn't do anything. Right here.
Click on this one.
What's this?
Sorry, guys.
Oh, your screen sharing is paused. Let's see. Here we go. So there. Okay, so that's where I can see everything. All right. So let me try this again. Oops. Resume there. Okay, can everybody see the PowerPoint? If somebody could shoot me a chat or just yell out whether you can see it or not. Here's the
I can see escrow disputes and a teal
Perfect.
background and the thumbprints on the left.
Okay, perfect. Thank you. Okay, so we are going to talk escrow disputes. This presentation I did for a much longer hour-long presentation, so I am going to cut it a little bit short because I really want to make sure that that we have time for questions and answers. That's really the purpose of these events, and I don't want to have to cut anybody off if you came with questions for us. So I'm going to go through it all, but I will probably shorten it a little bit or skip a couple of slides. But if you have questions on any of it, of course, we're here to answer those. So the first thing that we need to take a look at when we're talking about escrow disputes are the default provisions in the contracts when it comes to either a buyer default or a seller default. So this first slide here, and I've actually just quoted the language from the contract, talks about a seller's remedy in the event of a buyer default. So if a buyer defaults on the terms of the contract, the seller has two options. The first remedy is the seller can keep the buyer's deposit in full settlement of any claims. So that means that if the seller chooses this option, that is the seller's only remedy. They cannot keep the deposit and sue for additional money. They cannot keep the deposit and sue for specific performance, which we'll talk about in a moment. So that's option number one. Option number two is this underlying language here that the seller may proceed in equity. What that means is a cause of action for specific performance. This is a remedy that is unique to real estate. And basically, instead of asking a judge or a court to award monetary damages, you're asking a judge to force the buyer in this case to go through with the purchase of the property. You're asking the judge to literally enforce the terms of the contract. So those are the seller's two options in the event of a buyer default. In the event of a seller default, the buyer has options as well. The buyer, in any case, gets a return of their deposit money. It's the buyer's money, they get it back. In addition to that, they get to either file a claim for damages, so that would be monetary damages, or they may seek specific performance, which is the same remedy. In this case, it would be asking a court to force the seller to go through with selling the property to this particular buyer. So those are the options that the buyer has in the event of a seller's default. When we are looking at a default under the contract and we're looking at these remedies, the contract I guess I should back up. I'm referring to the FAR-BAR contract right now. I will touch very briefly on the CRISP contract. But for purposes of this discussion, we are going to be focusing on the FAR-BAR. Both the as-is and the standard FAR-BAR have the same default provisions. So those are the contracts that we're talking about. So once a buyer or seller chooses which remedies they want to pursue, there's a very specific procedure that the contract lays out that has to be followed. And today we're going to focus on that procedure as it relates to escrow disputes in particular, because the procedure is a little bit different. So if we look here at the language on the screen, at the moment that an escrow dispute arises, so one party sends a cancellation, the other party refuses to sign the cancellation. A dispute has arisen, and the contract says that from that date, we have basically what's in practice a 10-day waiting period. The parties over the next 10 days have to attempt to resolve the issue amongst themselves. They cannot file a lawsuit. They cannot force mediation. There's this 10-day period where the intent of the contract is to see if the parties can work this out on their own amongst themselves. If that fails, we proceed to step number 2. So we wait the 10 days, the parties cannot work it out. Step number 2 is what's called pre-suit mediation. So it is basically mediation that is required before either party can file a lawsuit to recover the escrow deposit. So this paragraph B here, 16B is what specifically references this mediation. It talks about what mediation rules have to be followed and all of those sorts of details. If the parties go to mediation, which is a process in front of a neutral mediator in a second attempt to try to resolve the issue without court intervention, we move on to step 3, which is going to be filing a formal lawsuit. If the escrow dispute cannot be resolved either directly between the parties and their agents or by a formal mediation, the party's only other remedy is to file a formal lawsuit. And at this point, they're able to. I want to touch very quickly on attorney's fees and court costs. So for the mediation process, the contract provides that both parties have to split the mediation fees equally. They also have to pay their own attorney's fees. So even if they go forward and file a lawsuit and they prevail or they win at the end of the lawsuit, they still have to pay their own attorney's fees and 1/2 of the mediation fee. They will not get reimbursed for that. However, once a formal lawsuit has been filed and there is a prevailing party at the end, so the judge has made a determination of who wins and who loses, that winning party does get their court costs and their attorney's fees reimbursed by the other party. So in evaluating these cases, more often than not, especially if we're talking residential today, the escrow disputes are not of an amount that really make it worth, months and months of litigation and thousands of dollars in attorney's fees and court costs. However, this provision makes these remedies a lot more accessible to the parties, because if you're confident in your position and you end up prevailing, you get reimbursement for all of those out-of-pocket costs and attorney's fees. So it's not a perfect remedy because you do have to take that risk up front, but it is a lot better of a remedy than, like we'll see, for example, in the CRISP contract, where you don't get reimbursement for those fees and costs. Okay, so I will touch very briefly on the CRISP contract. I do still see it, so I feel there is a need to address it, but I'm not going to spend a ton of time on it. Under the CRISP contract, the buyer's remedies in the event of a seller default are the exact same as under the FAR bar. The buyer gets their deposit back, and then they can sue either for money damages or specific performance. If we look at a seller's remedies in the event of a buyer default, the remedies are also the same as we saw under the FAR bar. The seller can either keep the deposit as full and final settlement of all claims, or they can seek specific performance. They have the choice of the two. The dispute resolution provisions in the CRISP contract are very different. So if you recall, under the FAR bar contract, there's that 10-day waiting period where the parties have to basically try amongst themselves to resolve the issue if they're able to do that. Under the CRISP contract, there is a 30-day period. However, the parties are required to attempt to resolve the matter through mediation during these 30 days. So there really is no waiting period before we get to mediation under the CRISP contract. It is a 30-day period from the initiation of the dispute for the parties to mediate. If the parties do not resolve the issue under mediation, the CRISP contract gives 3 options. The parties can either go to arbitration, they can file a formal lawsuit in civil court, or they can resolve the issue through the FREC process that they have for escrow disputes. Of note here for the CRISP contract is that attorney's fees are not available in the event that formal legal action is commenced. So the mediation fees are split equally between the parties, just as in the FAR. However, if a formal lawsuit or a formal arbitration is initiated, each party has to pay their own attorney's fees. So if we're looking at a $5,000 escrow dispute and it's going to cost you, which by the way, arbitration is very expensive when you're comparing it to civil court, the expenses are more than likely going to exceed the $5,000 deposit. So in reality, the parties have no remedy because it doesn't make financial sense to pursue those remedies. This is one reason why I don't like using the CRISP contract, but that's a topic for another day. I won't go into that. So that's a very broad overview of the process that has to be followed under each contract, the FAR contracts and the CRISP contract, in the event of an escrow dispute. And I'm going to give a real life example in a moment, but I want to just briefly mention in almost all transactions, residential purchase transactions, the deposit is going to be either held by an attorney doing the closing or the title company. The title company or the closing attorney has a remedy as well if there is an escrow dispute and that money is sitting in their escrow account and they want it out. That remedy is called an interpleader action. And what that is a formal lawsuit that we'll say title company just for purposes of this example, but it is a formal lawsuit that the title company would file. They would name both buyer and seller as defendants in that lawsuit. And basically they are depositing the escrow deposit with the court and telling the court, here's this money. I have no interest in it. I don't want it in my account anymore. I've named the buyer and seller who may or may not have an interest in it. Court, you deal with it. I don't want the funds anymore. So it doesn't necessarily harm the buyer and seller for the title company to initiate that action. Because at that point, it would be up to the buyer and seller to make their arguments to the judge as far as who is entitled to that deposit. But why we want to avoid that result is because the title company is entitled to take their costs and attorney's fees out of the deposit if they file that interpleader action. So again, if we're talking a $5,000 or less deposit, a nice chunk of that is going to be eaten up in the title company's costs if they move forward with that interpleader action. So I always reach out to the title company. If I'm handling the case, I will offer to have those funds put into my trust account so that we don't risk losing any of the deposit by the title company moving forward with an action of their own. So I wanted to throw that in there. That typically doesn't happen unless we're talking 6+ months of an escrow deposit being stuck in the title company's account. Usually toward the end of the year, they contact me to file these because they want these deposits off of their books. But usually the parties do end up working it out or pursuing formal legal action within that time period before the title company would take action on their own. So I want to go through a real life example. This was a 2015 case that I actually had in my office. And I used this case in many of my presentations for many different examples. But this was an escrow dispute. This was a as-is FAR contract that the party signed. The effective date was October 12th, 2015. The escrow deposit was $3,000. So that is, I would say, a fairly typical amount for an escrow deposit, but it is definitely on the low side when we're talking, whether litigation is going to be a good financial decision or not. Closing was set for November 30th, 2015. The actual language on the contract was on or before November 30th, 2015, which is not great language to use. And this case is an example of that. On the date of closing, the buyer requested an extension. The buyer's lender didn't have the loan documents ready. They needed several days of an extension. The seller refused. The seller had actually ended up getting a full price backup offer for cash and wanted to exercise that offer if they could. So when the buyer needed the extension, that was the seller's opportunity to move forward with their backup offer. So buyer obviously doesn't close. Buyer is upset and wants their escrow deposit. Seller saying, well, I don't think you get your escrow deposit because we're at closing and you didn't close and we're past the financing contingency deadline. So the next step is to refer back to the FAR bar contract and to go through that procedure that has to happen in all escrow disputes. So we first had to wait the 10 days before we could do anything. Needless to say, you can see this case made it to litigation, so the parties did not resolve it within that 10-day waiting period. The next step was to attend formal mediation. We did that, we go to mediation, we are unable to resolve it. At that point, there are two options, as you can see here on the screen. Either party, either buyer or seller, can file a lawsuit for return of deposit, or they can do nothing, and the title company or the escrow agent can file their interpleader action. This case actually was initiated by the seller. They filed a formal lawsuit against the buyer for the escrow deposit. The seller did get the escrow deposit back. But I want to finish with kind of some practical considerations on whether something like this is even worth pursuing, because that's the first question I get. I have agents call me all the time. Hey, it's looking like we're going to have an escrow deposit dispute. Is this even worth it? How do these things usually end up getting resolved? What's the end game here for my client? There are a couple of things to consider. So obviously the value of the claim. How much is the deposit? A $2,500 escrow deposit is very different from a $25,000 escrow deposit when we're determining whether we should move forward or not with legal action. So that's step one. The second step to look at, which is my job, is entitlement. Who's entitled based on the facts, the scenario, and the contract language? Who's entitled to the deposit? Escrow deposits are one of the few areas in the law that are black and white. And so I can usually give a pretty clear answer on who is entitled to the deposit. And I'm going to go ahead and stop that screen share here. And then finally, we need to look at the costs involved to get you there. So what is it going to cost in court fees? What is it going to cost in attorney's fees? And is that something that is worth it for me to pursue? So those are the things that I can help you evaluate with your client. The answer is going to be different in all cases, but those steps are very important, and those considerations are very important to talk about up front, because usually with escrow deposits disputes, the parties are very emotional and upset right when it happens. And so even if it's not a lot of money, it's based on the principle and they want to move forward and teach this other guy a lesson, and you know how that goes. But 3 months later, after they're paying an attorney every month and they're stuck in this court case and they're stressed out, their tune changes very quickly. So to be able to discuss the process and the fees and everything up front will really allow the clients to make an informed decision themselves. So I've talked way too long on this topic. Hopefully it was helpful. Hopefully you've learned something. We will go ahead and open it up for questions and answers at this time. You can either chime in verbally with your questions, or if you want to put your questions in the chat, we will be monitoring those so that I can go ahead and make sure we get everybody's questions addressed. So go ahead whenever you all are ready. Can you let me know if I have any? And I will start calling on people if nobody asks me any questions. That's a joke, but ask me questions. So side note, I will let you know that this is the first Get Real event that we have offered an in-person option. And we did have some in-person RSVPs. And so we got here early and we set everything up, and I will just show you our in-person attendees here. So it looks like Zoom is still the preference. I do think we will continue to offer the in-person option. It's right here in our office. It is not a hassle or a big deal at all for us, but this one was not successful as far as the in-person option. So, but like I said, we'll continue to offer it, and I think it will continue to grow as we kind of get back to normalcy a little bit. So, and Angela's apologizing. No need to apologize. I wasn't doing that to make anybody feel bad. I'm more just kind of laughing at ourselves, and we have a lot of snacks and muffins to eat.
Come stop stop by and say hi and grab some snacks.
Yes, we have goodies for you if you would like to
Swing by the office.
stop by. Okay, so we have a question here in the chat. If there's no appraisal contingency in place on an offer, but the home does not appraise, can the buyer technically get a loan denial and get their deposit back based on the appraisal? The answer is yes. The trick with these, so there is an appraisal contingency basically built into the financing contingency, because if it doesn't appraise, the loan is going to get denied on that basis. And that is a basis for the buyer to cancel the contract and get their deposit back. However, the way this usually plays out is the appraisal doesn't come back until toward the end or after the expiration of that financing contingency period. And so oftentimes we're looking at, well, the financing contingency period expired, the property didn't appraise, so the buyer can't move forward and they want out. If the financing contingency period has expired, the buyer cannot cancel and get their deposit back. They can cancel, but they're not entitled to their deposit back. So the purpose of the appraisal contingency is basically to extend the buyer's opportunity to cancel on that basis beyond that financing contingency deadline. So if we're in the financing contingency period, yes, they can cancel, get their deposit back. If we're past that period, no, they cannot unless you have that separate appraisal contingency addendum with the contract. That is a very, very, very common question. So thank you for asking that one. And of course, in this wacky market that we're in right now, that is coming up very often. Appraisal issues are coming up very often. So thank you for the question.
I'm just gonna talk. If I'm on the listing side representing the seller and this scenario happens, which it has, and they are pointing out that the appraisal is low and they can't afford to pay the difference because we won't drop the price. Is there any way to prove that they do have the money? Like somebody can put down that their loan to value, like they'll put down 100 grand on a house, but then if it doesn't appraise for, let's say they're short 5,000 and then they tell us, well, we don't have 5,000. They can still get a loan denial because any lender will give them that. How would us representing the seller, is there a way to prove that or make them prove it?
So we have to look at the financing terms in the contract. So the percentage of the purchase price that the buyer is financing, and that's what the contract contingency is based on. So if they're financing 80% of the purchase price and they don't want to pay $1 over that if it doesn't appraise, even if they can afford it, there's nothing you can do as a seller to force them to contribute that additional cash. Does that make sense?
Yeah.
But if the contract says they're going to finance 80% of the purchase price, but during the loan application process and working with their lender, they want to finance a lesser amount or a higher amount, and they get denied on that basis, you can enforce the terms in the contract. You can't enforce anything beyond those terms, whether they can afford it or not. So that is coming up a lot as well. And usually I'm seeing that sellers giving a little, buyers giving a little, and they kind of meet somewhere in the middle, but there's no way as a seller to force them to commit cash above and beyond that, the financing amount that is part of the contract.
Okay, thank you.
You're welcome.
Cristen, you had mentioned that it's never a good idea to put in the closing date on or before. Why is that?
Yes. So when I teach contract classes, I always throw that in there, and I always get a little bit of kickback from agents. So the case example that I use to kind of show the escrow dispute process is a perfect example of why I don't recommend using on or before language in that closing date section. The bottom line is it creates ambiguity. It creates the possibility for buyer thinking, well, I can close early if I'm ready. And the seller thinking, well, I have until X date to get my stuff out and to be ready. and they're not communicating with each other, and they're not on the same page as far as when closing is. Is it on the date or is it before? So what happened in the case that I referenced earlier is the closing date was on or before November 30th, which was right after the Thanksgiving holiday break. Buyer really wanted to close early. So they had their lender in gear. The lender had everything ready prior to the Thanksgiving break. The loan package, everything was ready to go. They contact the title company. Title company says, yep, we can be ready before the Thanksgiving holiday. They go to the seller and say, hey, we're ready to close early. Everything's in place. Let's go. And the seller says, what are you talking about? I'm not ready to move. I have until November 30th. I can't be out. So what happened at that point was the buyer's loan documents all had to be redone. And that loan package basically got kicked to the end of the line behind all the other loan packages that that lender had to do. So combine that with TRID was very new at that time and the Thanksgiving holiday, the lender couldn't get the loan documents redone by November 30th. And they needed, I think it was a 2-day extension because of all of these issues. Had that language not said on or before, the buyer never would have been under the impression that they could have closed earlier, never would have tried to work with their lender to get the package done early. None of this would have happened. Now, great communication could have avoided this as well. So that is why I don't recommend it. And also, if we have a hard closing date of November 30th, for example, and the parties are ready and they want to close on November 20th, that's a simple 1-sentence addendum and we can close early. Both parties just have to agree and sign off on it. So it's a simple fix, but litigation and disputes come out of the parties not being on the same page and ambiguities in the contract. And so anything we can do to limit the potential for an ambiguity is what we need to do. We need to be as specific as humanly possible to try to avoid disputes down the road. And to me, that on or before language creates ambiguity and kind of invites miscommunication and potential issues to come up revolving around that date. So that's why that is my opinion. If you choose not to follow my advice and use that language in your contracts, you're not hurting my feelings, but that is why I don't typically recommend it.
Thank you. I appreciate that. And I'm looking forward to a contract class.
Yes, so I actually was just working with my marketing team on some different classes. We want to start incorporating in-person classes again, and we will also make them available by Zoom. Contracts classes are always very popular. So thank you for that. We'll go ahead and get that in the works, and I'll make sure to get that information out to everybody once we choose a date.
Hey, Kristen, I have a quick question.
Sure.
Additional escrow deposits. Good, bad, do it, don't do it. Why?
I don't think they're generally good or generally bad. I think depending on the circumstances and depending on who you're representing is what you kind of need to look at. But in and of themselves, they're not good or bad. Obviously, additional deposits are going to mean the buyer has more skin in the game. It's going to mean that the seller's a little bit more protected. So generally speaking, if you're a buyer's agent, you want those deposits to be as low as possible. If you're representing a seller, you want them to be as high as possible, especially considering what we discussed earlier is the seller's only remedy is that deposit. So when I see, contracts for $700,000+ purchase prices and a $2,000 deposit, that ratio does not protect the seller at all. If there were a breach in the contract, the seller's only remedy is that $2,000. So we need to look at, the length of time between contract signing and closing. The shorter the length of time, the less risk there is, the lower the deposits can be. If we're, as far as additional deposits, if the buyer wants to break up their deposits and say, hey, we'll pay $2,500 now, and then after due diligence, once we're sure, after inspections, once we're sure we're going to move forward, we'll pay an additional. It's just really using creative ways to kind of negotiate a deal that will work for both parties. So there I think are a lot of factors that you have to consider in those. And I think it's just an additional tool that you have to negotiate a deal. versus losing a deal because a buyer doesn't want to put $10,000 up front and a seller is demanding $10,000 deposit. So that probably wasn't a very specific answer to your question, but I think they can be useful in certain circumstances, and I don't think they're good or bad per se. All right, what other questions do you guys have for me?
Sorry, you froze there, but thank you.
Oh, I'm so sorry about that. All right, what other questions do you guys have?
Okay, good question. Kristen, so with the escrow dispute, on the example you gave, you said that the buyer's lender needed another couple of days to get the packet redone. And the seller was unwilling to wait for that because he had a backup cash offer. Was the original buyer's offer that much lower than the full price cash offer to go through? Because now he's waiting 10 days for the waiting period. And then going through mediation, over $3,000. Would he not have been better off just to wait the extra 2 days and close with the original buyer? Or was the money difference that vast?
So there's a lot more to this case than I kind of went through today. I represented the seller in this case, and he's an investor, and I've represented him in a lot of different types of issues. And so he called me when the buyer requested an extension, and he said, "Do I have to grant this extension?" And so I looked at the contract, and if the extension was a result of the disclosure requirements from TRID, the answer is yes, you have to extend it up to a certain number of days. So my answer to him was, of course, it depends. It depends on why the extension is being requested. So we sent a request to the lender asking, why do you need this extension? They sent a letter back. And he said, well, we had it done early, and then it got kicked to the back of the line. And then with the Thanksgiving break, we had people out, and it was just really busy, and TRID is really confusing. So we just needed the extension. So based on the lender's response and based on the contract language, my answer to him legally was no, you don't have to grant the extension. Morally, my answer would have probably been different. But based on the language of the contract, he did not have to. I don't recall exactly how much higher the cash offer was. I think it was pretty significant, especially for that time. We were not at all in a market like we're in right now. But keep in mind too, that he was able to execute that backup offer, close in 3 days before this escrow dispute was ever resolved with the buyer. So it's not like he had to wait for the 10 days and the mediation and the lawsuit to be resolved before he could go sell it to somebody else. Nothing prevents a seller from selling it to somebody else in this situation. So I think morally the answer is different from the legal outcome. I also think this case was one that we decided to pursue in court, not because of the dollars necessarily, but because there were so many issues going on at the time with the TRID disclosures. And it was a case of first impression. There was no previous law or previous court decisions on this issue and on the required extension because of the new disclosure laws. And so it was a very unique legal case for us. For that reason, the $3,000 I don't think was the motivating factor. But in general, is it worth litigating over $3,000? Absolutely not. He spent significantly more in attorney's fees, like not 10 times more, but pretty close to it in this case. But again, we were litigating a much more complex legal issue of first impression. So there was that kind of wrinkle in it as well.
Thank you.
Okay, so there's another question in the chat. I have had listing agents in this market force the buyer to add language like escrow deposit goes hard after inspection period in the additional terms. When adding language to a contract, is it safe to add what someone sends you, or should language only come from attorneys? I love this question. I also do a presentation on the unauthorized practice of law, because as real estate agents, you're not a lay person, but you're also not an attorney. The law allows you to do more than a lay person, but not as much as an attorney without crossing that line of practicing law. So what the law allows you to do is to fill in pre-approved form contracts. So you can fill in the FAR-bar contracts, you can fill in a form lease, you can fill in the form addenda. What the law does not allow you to do as a non-attorney is to draft language yourself. So you cannot take the additional terms or a blank addendum and just start typing in terms yourself. That is the unauthorized practice of law. It happens all the time, every single day. But technically it is not legal for you to do that. What I have done many times for many brokerages is we've created template addenda for different things approved by me so that you as agents can fill those in, but you cannot draft and create them yourself. So the answer to your question is, if it's something you're creating from scratch or the other agent is creating from scratch, you need to have an attorney look at it to protect yourself. Okay, we have another question in the chat. When the title company is holding the escrow deposit and there is a dispute, is there a process or steps that the title company will follow? I find that all title companies handle this very differently. So I don't think there's one answer that's going to apply to everyone. But typically the title companies are not going to do anything for a period of time. Whether that's 3 months, whether that's 6 months, whether that's a year, is going to depend on the title company and probably the time of year. So when the title company takes that next step is going to be different across all title companies. But when they do decide to take a next step, that next step is going to be the same, which is filing a formal interpleader action. So what I always suggest is that the agents communicate with the title company and say, hey, the parties are trying to work it out. Please don't file an interpleader, or if you do, just give us a heads up and let us know, because that way the parties themselves can go ahead and initiate the action, or if they're represented by an attorney, they can take that escrow deposit out of the title company's account, put it into their attorney's trust account, so that they don't risk the title company moving forward and incurring expenses before they're ready. Does that answer your question, Bill? All right, yeah.
All right.
All right, any other questions? We have time for a few more. Oh my God, the thing is on the TV and not on the computer. Okay.
I have one last question.
Sure.
You guys are freezing as well, so I didn't get the answer for the last one, but I hope you guys can hear me clearly. My computer's freezing.
Yep,
but,
I'm gonna stop the video quickly so that hopefully we can hear you and get your answer, and then.
Can you hear me now?
I can, yes.
Okay, I can hear you as well. So when it comes to adding language, a lot of nowadays with the competitive market, we're adding stuff like buyers willing to pay X amount over whatever it appraises at, not to exceed the purchase price, right? So when you offer that, I've ran into a lot of situations where even if it appraises low and we do pay the difference, even if we're paying $15,000 over appraisal, people are still rejecting it at the end of the day, and they have that right to renegotiate everything and cancel. or do they have to agree to those terms and follow through with it?
So are you asking who would have the right? Are you asking, does the buyer have,
Right.
does the seller have a right if the buyer is willing
Does
to
the
contribute?
buyer have the right to pay? So if we're buying something for 200,000 and we're saying we'll pay 15 grand over whatever it appraises at, and it only appraised at 150, the seller still has the option to overall cancel that deal, right? Not accept the 15 grand over 150 when they're anticipating a really high number? Or do they have to sell it at 15 grand over whatever it appraises at once they sign that contract?
They don't have to sell it at, in this case, the 175. So in this case, the contract would basically be back open for negotiations. As far as who gets the deposit in that case is going to depend on the deadlines and loan denial and all of that.
Yeah.
But the seller is not forced to accept any terms unless the buyer is going to move forward and pay cash for the full purchase price. They have the right to do that. Now, once the buyer gets a denial letter, the seller does have a window of time to cancel the contract. They don't have to move forward. Even if the buyer says, I'll pay cash to make up the difference, the seller does have, I believe it's a 3-day window to cancel at that point. But if we're talking about reduction of purchase price to make the numbers work, the seller never has an obligation to reduce the purchase price. They can always cancel.
Okay.
All right, and I just want to go back and readdress Bill's question. I think I froze during a part or all of that question. So I'm sorry, Bill, I'm going to go ahead and readdress that one really quickly. His question is, when the title company is holding the deposit and there is a dispute, is there a process or steps that the title company follows? And my answer is, that's going to depend on the title company themselves. So the only process that the title company has available is to file an interpleader action with the courts. However, when the title company takes that step is going to depend on each different title company. Some will do it very quickly after 30 or 60 days. Some might wait 6 months. Some might wait even longer than that. So my recommendation to you as agents would be to make sure you're communicating with the title company. You're letting them know that the parties are working on trying to resolve this. Please do not file an interpleader action yet, or if you're going to, please give us advance notice, because if you have an attorney representing your client, that deposit can be put in the attorney's trust account. And that way the parties don't risk having the title company take formal action and incur expenses while they're trying to resolve things. So it's really up to the title company how or if they want to proceed, and that's why it differs. But the key here is just communicating with them and making sure that you're keeping them in the loop and they are keeping you in the loop as far as any proposed action goes. Were you able to get that answer, Bill? All right, perfect. And I'm going to attempt to turn on my video again. Any last minute questions? I think we have time for one more.
Can I follow? Can you hear me?
I can, yes.
Okay, I want to follow up with a question from before regarding if the house appraises lower than the purchase price that the buyer offered. And if the buyer says he was willing in the contract to go up 15,000 over appraised value, right? But it's still lower than that 200,000 that they had agreed in the contract. And you said the seller can cancel. What if in another scenario where the buyer decides, oh, I could go all the way up to 200, putting up more than 15,000 to go up to 200. Does the seller still have a right to cancel, or can the contract go through?
The seller only has a right to cancel in the event that the buyer does not get a loan approval by the loan approval deadline. So in this scenario, if the buyer is willing to contribute enough cash to make up the difference, the buyer's loan is going to be approved. So the seller cannot cancel in that scenario. Does that answer your question?
Yes.
Okay. All right. If you did not have an opportunity to ask a question of us, feel free to email me directly. I will put my email in the chat right now. And then Jen has some closing remarks. Thank you all so much for the awesome questions and for coming this morning.
Thank you so much for attending today's Get Real with Attorney Martinez.
Kristen,
These are monthly discussions occurring on the first Wednesday of every month at 10:30 a.m. We will continue. There you go. Sorry, everybody, I'm going to start again and apologize for the technology. Thank you so much for attending today's Get Real with Attorney Martinez. These are monthly discussions occurring the first Wednesday of every month at 10:30 a.m. We will continue to offer this via Zoom or in person. These discussions are appropriate for any real estate professional, homeowner, and anyone interested in real estate matters. Next month's Get Real with Attorney Martinez will be Neighbors Driving You Crazy? Learn all about nuisance laws, easements, and trespassing. You can register via Eventbrite. We look forward to seeing you again on Wednesday, July 7th. Thank you all again. Have a great day.
Thank you. Sorry about the goof up with the technology, but we will work on that for next month. Thank you all so much.